Many people, when they're hurt on the job, are concerned whether they're going to be able to go back to their former employment or whether they're going to be able to work at all. This is a natural concern that all people have because as Americans, our job is very important to us, and the economics of our job are also important to our families and our livelihoods. First thing that you need to know is that most people do not end up with a permanent injury which prevents them from returning back to work. And you need to give yourself time to go to your doctor, get the care and treatment that you need in order to make sure that you get better. However, when you get to maximum medical improvement, or a point when your treating physician tells you that there is nothing else that you can do to get better, and you have tested that potentially with a second opinion doctor that says this is the best that you can be, there could be a determination that you can no longer go back to your former employment or that you cannot work at all. The first test will be if you can no longer go back to your former employment, then your employer will be asked if they have another job within your company for you to return to. You may state that you only are doing a certain job, but under the law, your employer is allowed to determine if they are able to accommodate you within your restrictions. Typically, you will take some type of functional capacity test, or what is in common parlance known as an FCE, to determine what your job potential skills are, of what you can do and not do. You also may see a vocational counselor who may go through your past work experience and educational experience to determine with your prior skills and your educational level what jobs you may or may not be able to do in the future. Under the law, if your employer accommodates you and the accommodation that they are providing you will lead to a true career job for you in the future, that may be a job that, under the law, you would have to do into the future. However, if your employer is not properly accommodating you and the accommodation they are giving you is not a career and only temporary, then you may be eligible for vocational retraining to a different job. First, you may have to go out and look for work yourself, and most lawyers would probably recommend to you that you keep a logbook of the jobs that you are looking for to prove your diligence in looking for work. Once you have exhausted your ability yourself to look for work, after you have done a period of time, and people generally ask how long is that, there is no exact period of time. It's just a factual issue for every single person as to what they tried to do and were able to do and not able to do. Then you would be able to have a vocational counselor either chosen by yourself or potentially through the company to help you look for work within your specific restrictions and your specific background, and with you weighing in on the type of job that you would like to do in the future. They will help you prepare a resume, they will help you look for work, they will help you look for jobs, and however long that takes, under the law, you would receive what's called MMI payments, or payments as long as you are being diligent to look for work. So unlike somebody who does not have a job typically and has the stress of the economics of needing to get any job in the workers' compensation system, you will have an opportunity to look for work and be paid by your employer to find a job that will accommodate you into the future for a new career within your new work restrictions. This issue of looking for work within your new restrictions is oftentimes one which is very hard for people when they need to change their careers, and it is also a very difficult issue under the law, which you must have an attorney who practices in the field of workers' compensation, who understands these issues in order to help you so that your future life and the future career that you have is the one that you want.